Hello friends, hope you are all doing well. Today I will discuss on a very interesting topic, that is medical negligence. To start with, we should know a doctrine of law based on which negligence cases are decided, that is res ipsa loquitur. Res ipsa loquitur means the thing speaks for itself. It is a doctrine of law that one is presumed to be negligent if he or she had exclusive control of whatever caused the injury, even though there is no specific evidence of an act of negligence. And without negligence, the accident would not have happened. So, in a negligence case, to decide a negligence case, to decide whether there is any act of negligence or not, this doctrine of law is applied. Res ipsa loquitur. That means the thing speaks for itself. If a patient suffered from something, who is under the treatment, who is under indoor treatment in any hospital under any specific doctor, and something abnormal happens to the particular patient, then whether there is any act of negligence or not on the part of the hospital or on the part of the doctor, this doctrine is applied. Though a doctor is not an insurer for the patient, inability to cure the patient would not amount to negligence, but carelessness resulting in adverse condition of the patient would. So, doctor is not an insurer of the patient. A doctor cannot give any guarantee that the patient will be cured. Doctor will try his level best to cure the patient, but he cannot give any guarantee that he will be able to cure the patient. But if there is any act of negligence or carelessness resulting out of carelessness which affects the patient, that will become the liability of the doctor. So, when the liability of a doctor for the act of medical negligence arises is very much clear from this doctrine and its explanation. I am coming to the next slide. I will discuss some landmark cases on medical negligence, through which you will be able to understand the matter and the present legal position of medical negligence cases in India. One of the such landmark cases is Jacob Matthew versus State of Punjab, where the Supreme Court held that a professional entering into certain profession is deemed to have knowledge regarding that profession, and it is assured impliedly by him that a reasonable amount of care shall be taken to profess his position. When a person, after completing his course, enters the profession, that means he professes that he is in possession of sufficient knowledge over the subject matter. If someone starts practicing as cardiologist, it is implied that he has sufficient knowledge on cardiological matters. The person can be held liable under negligence if he did not possess the required skill to profess, or he failed to take essential amount of care to profess the said profession. Now a person practices, a doctor practices as cardiologist, but he has no degree for cardiologist. He is a simple MBBS. So the person is liable under negligence if he did not possess the required skill to profess. So in this case, as the doctor is only MBBS, that means he is a general physician. He cannot profess as cardiologist. So in this case, there is negligence on the part of the doctor, or he failed to take essential amount of care to profess the said profession. Say the cardiologists have the particular qualification, particular degree to practice as cardiologist, but while treating a patient, whether indoor or outdoor, whatever may be the case, he failed to take required amount of care in treating that patient. He prescribed some medicine without considering the age of the patient, or he prescribed some medicines for the patient which should not be applied on any pregnant woman, but he did not care, he did not bother that his patient is pregnant, and as a result of his carelessness, the pregnant lady suffered from something. Here the doctor is liable, doctor can be held responsible for medical negligence. The next case law, Guwahati High Court. The liability of the doctor cannot be invoked now and then, and he cannot be held liable just because something has gone wrong. If anything goes against the patient, first of all keep it in mind that doctor cannot give guarantee that the patient will be cured. Doctor only can make honest effort, doctor can only give honest fight to cure the patient. So for every adverse effect on the patient cannot be treated as medical negligence on the part of the doctor. For fastening the liability, a very high degree of such negligence was required to be proved. To put such allegations of medical negligence and to proceed against the doctor, very high level, high degree of such negligence is required to be proved. A doctor or a medical practitioner, when attends his patients, owes him the following duties of care. Guwahati High Court specifically mentioned 3 points which are treated as the duties of a doctor while attending a patient. A duty of care in deciding whether to undertake the case. First, the doctor who is meeting the patient have to decide whether he will undertake the case, whether he will start treatment of the patient or not. Say a patient is suffering from some urology problem and the patient went to a cardiologist. So in this case, the cardiologist have first to decide whether he will treat the patient or not. In this case, cardiologist is not entitled to treat any urology problem. So point number 1 is a duty of care in deciding whether to undertake the case. Number 2, a duty of care in deciding what treatment to give. When the doctor decides that yes, I will start treatment, then he will have to decide what kind of treatment I will do for this particular patient, because health condition of every person differs. I may have some history of cardiac problem. I may have some history of allergic issues. I may have many problems. Doctor has to decide what kind of treatment, what kind of medicine to be applied on this particular patient for his treatment, so that other issues may not arise. In any accidental case, many things may come in future, even after taking all due diligence. But this due diligence should be applied before prescribing any medicine, any treatment. A duty of care in administration of treatment. So, doctor first will have to decide whether he will start treatment or not. Second, he will decide what kind of treatment he will give. And third, the administration of that treatment. How he will administer that treatment. If a doctor decides that a particular patient needs some intravenous injections at least 4 to 5 times a day, in this case, doctor should advise the patient for admission in any hospital or nursing home for proper administration of such intravenous medicines, because at home it will be very difficult for proper administration of some intravenous medicines. It may be that doctor administered some kind of oral medicines, but while administering such oral medicines, a continuous observation on the patient is required. How that oral medicines are affecting the treatment in positive way or negative way. So in this case, the patient cannot be treated at home. The patient to be admitted in a hospital, because in a hospital this continuous observation is possible, at home it is not possible. So a duty of care in administration of the treatment. The next case law, it is on your screen. Himachal Pradesh High Court held that shifting of patient from one ward to another, very interesting judgment, very interesting observation by Himachal Pradesh High Court. The shifting of the patient from one ward to another in spite of requirement of instant treatment to be given to the patient, resulting in damage to the patient's health, then the doctor or the administrator of the hospital shall be held liable under negligence. In this matter, one Hindi film came in my mind. The famous film of actor Sanjay Dutt, Munna Bhai MBBS or something like that. I cannot remember the name exactly. Where Sanjay Dutt told the principal of a college that whether it is necessary to fill up this form and that form, do this formality and that formalities before starting the treatment of a emergency patient. An emergency patient needs instant treatment. Sanjay Dutt asked the principal of that medical college, who was Boma Irani, that whether it is necessary to comply with all these formalities before starting the treatment. Similarly, in this case, the Himachal Pradesh High Court held that shifting of the patient from one ward to another, in spite of requirement of instant treatment, the patient needs instant treatment. Otherwise, he may succumb to death or his position may deteriorate. But hospital authority decided to shift this patient from this bed to that bed, this ward to that ward. And this shifting caused damage to the health of the patient. Then the doctor or the administrator of the hospital shall be held liable under negligence. Now the next one, again Himachal Pradesh High Court, very interesting judgment. Before performing any surgery, the chart revealing information about the amount of anesthesia and allergies of the patient should be mentioned so that an anesthetist can provide ample amount of medicines to the patient. The doctor in above case failed to do so. As a result of the overdose of anesthesia, the patient died and the doctor was held liable for the same. Overdose of anesthesia, patient died due to overdose of anesthesia. And why this overdose happened? Due to some negligence on the part of the doctor, that he failed to provide this chart revealing information about the amount of anesthesia and allergies of the patient. And the anesthetist was unaware of it. And as he had no such information, he applied anesthesia in general course. And that general course became overdose for that particular patient. As a result, the patient died. The doctor is held responsible in this case. The next one is on your screen. The Andhra Pradesh High Court held that the hospital authorities were held to be negligent inter alia for not keeping the bathroom clean, which resulted in the fall of an obstetrics patient in the bathroom, leading to her death. A compensation of rupees 1 lakh was awarded against the hospital. The bathroom of the hospital was not clean. As a result, a patient fell on the bathroom and this accident resulted to her death. In this case, the hospital is liable for negligence because hospital is duty bound to keep the bathroom clean for the patient. The next landmark judgment of the Honorable Supreme Court. The Supreme Court reaffirmed that a hospital is also vicariously liable for medical malpractice perpetrated by medical practitioners engaged or retained by it. Vicarious liability of the hospital for any malpractice by the medical practitioner, means doctor, engaged or retained by the hospital. The court had observed that it is common knowledge that when a patient visits a hospital, they do so because of the facilities, reputation, and in the belief that the hospital's authorities will provide adequate treatment. A patient visits a hospital depending upon the reputation of that hospital. And when I visit a hospital, depending upon the reputation of that hospital, I keep some expectation in my mind that hospital authority will take such and such level of care. If the hospital fails to carry out its responsibilities via its physicians, whether they hired on a job or on a contract basis, the hospital must defend the acts of commission or omission on behalf of their doctors. Whether the doctor is there under their payroll or on contract basis, but the vicarious liability of the hospital cannot be denied. Though the negligent act was done by the doctor. Why hospital is vicariously liable? Because I am visiting the hospital keeping in mind the reputation of that hospital, and when I am considering the reputation of that hospital while I am taking admission or when I am going for treatment to that particular hospital, I keep some expectation that such a reputed hospital will take adequate amount of care for my treatment. And if any negligent act is done by a doctor who is under their payroll or on contractual basis, the hospital cannot deny its vicarious liability. The next judgment of Supreme Court is on your screen. A person who holds himself out ready to give medical advice and treatment impliedly undertakes that he is possessed of skill and knowledge for that purpose. In the earlier part of this episode, I was discussing this. Such a person, when consulted by a patient, owes him certain duties. That is, a duty of care in deciding whether to undertake the case, which was observed by the Honorable Guwahati High Court. A duty of care in deciding what treatment to be given, or a duty of care in administration of that treatment. Remember the observation of the Guwahati High Court I discussed earlier in this episode. A breach of any of those duties gives right to action for negligence to the patient. If there is any breach on the part of the medical practitioner, that will be treated as a medical negligence on the part of the doctor. Another judgment, Poonam Verma versus Ashwin Patel. Honorable Supreme Court held that a doctor registered as medical practitioner and entitled to practice in homeopathy only prescribed an allopathic medicine to the patient. A homeopathic doctor prescribed allopathic medicine. A homeopathic doctor is entitled to treat a patient in the treatment of homeopathy. He cannot do any allopathic treatment. The patient died due to such application of allopathic medicine advised, prescribed by the homeopathic doctor. The doctor was held to be negligent and liable to compensate the wife of the deceased since he trespassed into a prohibited field. Homeopathy practitioner, a homeopathy doctor, cannot do treatment in allopathy. This is treated as a trespass. Since he trespassed into a prohibited field and prescribed allopathic medicine to the patient, causing the death, his conduct amounted to negligence per se actionable in civil law. This is a very nice example. Nice case. The next one, landmark case of Kusum Sharma by the Honorable Supreme Court. To prosecute a medical professional for negligence under criminal law, it must be shown that the accused did something or failed to do something which in the given facts and circumstances res ipso loquitur. Remember the first slide at the very beginning of this episode. I am reading again. That to prosecute a medical professional for negligence under criminal law, it must be shown that the accused did something or failed to do something which in the given facts and circumstances no medical professional in his ordinary senses and prudence would have done or failed to do. So, Supreme Court gave a very nice guideline for prosecuting a medical practitioner. What is that? Either act of commission, which he should not, or act of omission, which he should not. He means a medical practitioner of ordinary sense and prudence. Either it can be act of commission or act of omission. In both the cases, based on the doctrine of res ipsa loquitur, a doctor, a medical practitioner can be prosecuted. The next one, Supreme Court. An officer in the malaria department filed a complaint against the hospital for negligently conducting his wife's treatment. The hospital treated her for typhoid and giving medication for the same instead of malaria fever. Instead of malaria fever, the hospital started treatment for typhoid. Very nice. The complainant's wife complained of respiratory trouble. The complainant also brought forward to the notice of the authorities that artificial oxygen to the patient. In accordance with the complainant, at that stage, artificial oxygen was not necessary, but without ascertaining the patient's actual necessity, the same was given. As the treatment has been given for typhoid, the medicines would have been for the exact causes, and cure also has their side effect. They have been very negligent while discharging their sole duty towards their patient. Patient admitted for malaria in the malaria department, but the hospital started treatment for typhoid and did all sorts of things that may be required for typhoid. This is an act of negligence on the part of the doctor or hospital. The next one, Samira Kohli, Supreme Court. The court held that consent given for diagnostic and operating laparoscopy does not consent for a total hysterectomy with bilateral salpingo-oophorectomy. The appellant was not a minor, neither mentally challenged or disabled. As the patient was a sane adult, there was no question of someone else giving consent on her behalf. The appellant was under anesthesia, thus unconscious, and there was no emergency. The respondent should have waited till the appellant regained consciousness and gave proper consent. So, hysterectomy with bilateral salpingo-oophorectomy. I don't know what is that. But that has been done at the time of our laparoscopic surgery without taking consent from the patient, and it was done when the patient was unconscious due to anesthesia. The question of taking patient's mother's consent does not arise in the absence of an emergency. In case of any emergency situation, consent could have been taken from her mother or from her family members. But in this case, such additional thing was not an emergency requirement, and doctor could have waited till she gains her conscience. The issue was not about the accuracy of removing reproductive organs, but the failure to obtain consent for removing reproductive organs, as performing surgery without taking consent amounts to an unauthorized intrusion and interference with the appellant's body. Doctor removed the reproductive organs of a female without taking her consent. That has been treated by the court as a intrusion, unauthorized intrusion and interference with the appellant's body. The respondent was restrained from paying the surgery fee wholly, but directed to pay only the compensation of unauthorized surgery. So, unauthorized surgery without taking patient's consent in a non-emergency situation where by such surgery the reproductive organ of that patient was removed is treated as medical negligence. Again, Supreme Court in Messrs. Spring Meadows Hospital. In this case, the court held that when a young child was carried to a private hospital by parents and treated by the doctors, then not only just the child but his parents are also treated as a consumer under the Consumer Protection Act. Hence, a parent can claim compensation under Consumer Protection Act. A child was taken to a hospital. Child's parent took that child to the hospital. The child was treated, not his parents. But the child as well as child's parents are consumer and can be treated as a consumer as per within the scope and ambit of the Consumer Protection Act. Therefore, the court ruled in favor of the child's parents and the child who was the services beneficiary. The hospital argued that adequate care had indeed been taken and hence would not be authorized to pay compensation for the mental agony the parents have went through. They disputed that the parents would not come under the definition of consumer in the Consumer Protection Act. The court accurately pointed out that this contention was false since consumer's definition under the Act includes parents. So, very simple thing in this case is when a child is taken to a hospital, the child as well as his parents are consumer within the scope of the definition of consumer under Consumer Protection Act. Supreme Court in Arun Kumar Manglik case held that while deciding whether a medical professional is guilty of medical negligence, following well-known principles must be kept in view. Now, few guidelines given by the Supreme Court to deal with the medical negligence cases. Number 1, negligence is the breach of duty exercised by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. I discussed it earlier. So I am going to the next. Number 2. Negligence is an essential ingredient of the offense. The negligence to be established by the prosecution must be culpable or gross and not negligence merely based upon error of judgment. Say I have malaria, I have high fever, and in my area lots of patients are going to the local hospital having malaria, and I also with high fever went to the local hospital, and the doctor over there, without blood test started treatment of malaria under the concept that lots of people in that particular area are suffering from malaria. He advised to start the medicine immediately and go for blood test on the next day. After the blood test, it was detected that I don't have malaria but dengue. Here, a mistaken judgment, error in judgment. Negligence is an essential ingredient of the offense. The negligence to be established by the prosecution must be culpable or gross and not negligence merely based upon an error judgment. This is an error of judgment, not negligence. As lots of people are suffering from malaria in that particular area and the hospital is getting patients in bulk regularly who are having malaria, the doctor was under the impression that I also have malaria because I have high fever. Doctor started malaria's treatment and advised me to go for blood test on the next day. And after blood test, it was found that I don't have malaria but dengue. So there is no negligence on the part of the doctor. This is merely an error in judgment. Number 3, the medical professional is expected to bring a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. Neither the very highest nor very low degree of care and competence judged in the light of the particular circumstances of each case is what the law requires. So the medical professional is expected to bring a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. Reasonable degree. Neither the very highest nor very low degree of care and competence judged in the light of the particular circumstances of the case is what the law requires. So the law requires reasonable amount of care, reasonable degree of care, not the highest degree of care, not the low degree of care. Number 4, a medical practitioner would be liable only where his conduct fell below that of the standards of a reasonable, competent practitioner in his field. A medical practitioner would be liable only where his conduct fell below that of the standards of a reasonably competent practitioner in the field. Somehow it says that a doctor is expected to administer such a treatment as is expected from any other similar doctor. Not very high level of care, not very low level of care. Similarity, that is required. Next, in the realm of diagnosis and treatment, there is scope for genuine difference of opinion, and one professional doctor is clearly not negligent merely because his conclusion differs from that of the other professional doctor. In our field, we know that opinion of lawyers differ. My opinion is this, my other side lawyer's opinion is this, and after considering the entire thing, the judge's opinion is this. So there is difference based on a similar thing, based on a similar situation. Opinion may vary from person to person, and either of the opinion will be correct and the other will be incorrect. So, based on the same diagnosis, if there is any wrong opinion given by the doctor, that cannot be treated as a medical negligence, because opinion may differ. Next, the medical professional is often called upon to adopt a procedure which involves higher element of risk, but which he honestly believes as providing greater chances of success for the patient, rather than a procedure involving lesser risk but higher chances of failure. Just because a professional looking to the gravity of illness has taken higher element of risk to redeem the patient out of his suffering, which did not yield as desired result may not amount to negligence. To treat a patient, to cure a patient, the doctor may take higher amount of risk, ignoring the method of treatment which involves lower amount of risk. In the method which involves higher amount of risk, there is chance of success is higher. Where there is lower amount of risk, the chance to success is lower, and the doctor adopted the higher amount of risk, the procedure which involves higher amount of risk, with the expectation that he will be able to cure the patient. But unfortunately he failed. It cannot be treated as a medical negligence on the part of the doctor, as he adopted the method of treatment which involves higher amount of risk, and he failed because he had adopted that procedure with bona fide, and there was chance to success, but unfortunately he failed. There is no guarantee. The doctor cannot give any guarantee that he will be able to cure the patient. It is not possible for the doctor to give any such guarantee. Doctor can give only true effort to cure a patient, and in every case, if the doctor fails to cure a patient, the doctor should not be held liable under the medical negligence. Next, number 8. It is on your screen. Negligence cannot be attributed to a doctor so long as he performs his duties with reasonable skill and competence. Negligence cannot be attributed to a doctor so long as he performs his duties with reasonable skill and competence. He adopted higher amount of risk. The method involves higher amount of risk and failed, but he cannot be blamed, because negligence cannot be attributed to a doctor so long as he performs his duties with reasonable skill and competence. Merely because the doctor chooses one course of action in preference to the other one available, he would not be liable if the course of action chosen by him was acceptable to the medical profession. This is almost similar to the point number 6, but slightly different. There may be two kinds of treatment. One treatment, higher risk, higher chance of success. Another one, lower risk, lower chance of success. The doctor adopted the first one, higher risk, higher chance of success. If that procedure is approved in the medical profession, doctor cannot be blamed if the doctor failed to cure the patient by adopting that first one, uh, the method involves higher amount of risk. Next, it would not be conducive to the efficiency of the medical profession if no doctor could administer medicine without a halter round his neck. It would not be conducive to the efficiency of the medical profession if no doctor could administer medicine without a halter round his neck. Very simple. Coming to the next. It is our bounden duty and obligation of the civil society to ensure that medical professionals are not unnecessarily harassed or humiliated so that they can perform their professional duties without fear and apprehension. Very important thing. If we start blaming doctors for their every failure, doctors will not be able to treat in free mind. At the very beginning, and continuously I am saying repeatedly that doctor cannot give guarantee for a patient's cure. Only thing he can do, he can try to cure the patient with his best effort. So we should not harass a doctor in every failure of his. In that case, our society will suffer. The doctors will not be able to treat any patient in free mind. The next one. Number 10. Medical practitioners at times also have to be saved from such a class of complainants who use criminal process as a tool for pressurizing the medical professionals or hospitals, particularly private hospitals or clinics, for extracting uncalled for compensation. Such malicious proceedings deserve to be discarded against the medical practitioner. I think this point needs no explanation. Very clear to us. Next, the medical professionals are entitled to get protection so long as they perform their duties with reasonable skill and competence. They are entitled for protection. While we can hold a medical professional for medical negligence, it is also our bounden duty to give them protection for their every bona fide act. Otherwise, our society cannot survive. We should not blame our medical practitioner in all cases. And it is our duty to give that protection, to ensure that protection for the medical practitioner. We can file case against him for his genuine medical negligence, but should not try to extract money from the hospital, uncalled for money from the doctor or the hospital for their failure, because doctor cannot give guarantee for the cure. The interest and welfare of the patients have to be the paramount for the medical practitioners. So I think today's discussion on medical negligence, though I have discussed very few case laws in this episode, but all these case laws are landmark cases in our country. I think this will help the junior lawyers, the beginners, the litigants, as well as physicians also. And I want to give these through my channel, that while we can blame, we can prosecute a medical practitioner or a hospital for their medical negligence, but it is also our duty to give them protection against false or uncalled for prosecution for their every failure. Otherwise, it will be difficult for our society to survive if a doctor cannot treat in free mind. Ultimately, we the common people will have to suffer. With this, I will end this episode for today. Once again, I will request all of you to, if you like my channel, if you like my discussion, please subscribe, keep commenting, and in any question, in any matter, feel free to write to me to my email, or you can contact me over the phone number given on the screen. I will appear before you with my next video, which will also be very much interesting for all of you. Till then, goodbye, stay blessed.